All right, guys, welcome to part two. And we're still going to be talking about search and seizure or the Fourth Amendment. Um, there's a lot of case law on the Fourth Amendment, ability of police to search um, property, people, so forth. So it does get a lot of attention in textbooks. So let's finish talking about the Fourth Amendment. All right. So we talked about search and seizures with a warrant, without the warrant. There are different ways that we can conduct a search. So if we go back to what we talked about earlier, in order for a police officer, to get a search for your house, for example, they have to have probable cause, and that probable cause has to be supported with a sworn affidavit that whatever the police are looking for is located within your house. All right. On arrests, again, we should get arrest warrant where possible, but the law allows police to make an arrest without a warrant for crimes that are committed in public or in which you have probable cause to believe that a person was involved in an offense. So if I see two guys fighting, for example, I can make an arrest. If I don't see the two guys fighting, but I stop somebody leaving the scene in which, let's say, the other participant was stabbed, once I establish probable cause that this was the party that was involved in the stabbing, then I can go ahead and arrest. All right. I don't want to get into too much detail because you'll learn more about this in some other courses. But there are other ways in which a search can be conducted without a warrant. And so these are important to know, because if you're going to explain to somebody, for example, what does a police officer need to search my car, or what does a police officer need to search my house? Well, they have to have probable cause to search your house. Absent a consent, they have to have a warrant. There's an array of areas in the law in which police can search without a warrant. So, for example, search is incidental to a lawful arrest. So, for example, if you're walking down the street and I have reasonable suspicion to contact you, and I contact you, and during the course of my contact, I find out that you have a burglary warrant out for your arrest. The law allows me to search you incidental to that arrest. In other words, I can search. I can search your pockets. I can look in your wallet. If you're carrying a backpack, I can search through your backpack. I do not need a warrant to conduct that search. That is search incident to a lawful arrest. Searches during field interrogation, stop and frisk searches. And basically this means that if I stop you and I have reason to believe that you may be armed, then I can go ahead and frisk you. Now, frisking is not the same as search. Frisking, I'm only touching the outer portions of your person. So I'm running my hands across your pockets, through your waist, your arms, just to make sure that I don't feel something that I believe is a weapon, such as a gun. Stop and frisk does not give me the authority to go into your pockets, pull things out, open things up. That's not the purpose behind the stop and frisk. All right. So basically, I have to have reason to believe that you may be armed somehow. All right. And that gives me the authority to search. Now, if I do feel something like what appears to be a gun in your waistband, I can reach in and remove that gun, and that's perfectly lawful. All right. Searches for automobiles is under special conditions. What that means is I can search your automobile if I have probable cause to believe it contains evidence of a crime or fruits of a crime or instrumentalities of a crime. So I can conduct a search. I do not need to get a search warrant. I can search it based on probable cause. And that's because cars are mobile. In other words, by the time I go get a warrant, you could drive away, or an array of other things can happen unless I take the car and I search the car. So the courts have allowed police to search automobiles, but you have to still have probable cause. The probable cause established to search an automobile is no less than what I would have to search a house. I still have to be able to explain to the court that I believe that the property I'm looking for can be located within the automobile. All right. So I have to be able to articulate that, communicate that, write that in my report, so that the reviewing district attorney could also realize that I had sufficient probable cause to search the automobile. Search and seizure of evidence that is in plain view. In other words, if I were to lawfully stop you for example, running the stop sign, and as I'm talking to you, I can see the butt of a gun protruding from under your front seat, that is plain view. I can then seize the weapon. I can search because it's plain view. Or if I'm in your house because of a call for service of some type and I see something that's illegal, I can go ahead and seize it. All right, that's plain view. Okay. And finally, searches when consent is given. So if I go to you and ask if I can search your car and you say yes, then I can search your car. If I go to you and ask if I can search your house and you say yes, then I can search your house. All right. So consent is another way in which I can conduct a search without a warrant. So these will become important. I mean, if you wanted to explain to somebody the times when police don't need a warrant, here they are right here. I've articulated those for you. So search is incident to an arrest. You can look at these cases in your textbook. I've just highlighted them here. Stop and frisk, again, it's Terry versus Ohio. It's a 1968 Supreme Court case. We often call them a Terry stop, which means you have reason to believe that this person that you're contacting has engaged in some criminal activity or appears to be engaging in some criminal activity. Then you have reason to stop and detain them and find out what they're doing. Okay, that's a stop and frisk or a Terry stop. So take a look at these other type cases relative to stop and frisk. They're in your textbook. Again, searching of automobiles goes back to 1925 in Carroll versus U.S. So take a look at that. These cases are also outlined in your textbook. One of the more recent cases, U.S. versus Jones, and this is again using technology. Here, police placed a GPS device on a vehicle for an extended period of time and did not get a warrant. And the Supreme Court said that in order to place a GPS device on a vehicle, you need to get a warrant. Okay, prior to that, you didn't need to really get a warrant because the Supreme Court pretty much said a vehicle that's out in public, there's no expectation of privacy associated with that. However, in this particular case, the GPS was tracking this individual across the different jurisdictions, different states, and ultimately the Supreme Court ruled that in order for you to do that in the future, you need to get a search warrant, because basically that's what you're doing. You're searching what this person is doing, but you're just using a GPS. So in order to place a GPS on a vehicle, you now need to have a warrant. Plain view and open fields are another thing that is an exception. And basically, plain view and open fields, again, we already talked about plain view. Open fields is vacant lots. You don't need to get a search warrant to search a vacant lot. It was never designed that. The Fourth Amendment was designed for the residents in the immediate curtilage. In other words, the immediate area around the residence. Anything distant from the residence, an open field, did not apply. Consent is one of the most common ways police are able to search today. We ask people, and people say yes or people say no. You'd be surprised how many people say yes. All right, but the consent must be voluntary. The Constitution does not ignore the privacy rights of an individual who is present and asserting his rights when one occupant consents to search while the other refuses. So in other words, the courts have pretty much said that that person also has privacy rights. And so I cannot give the police authority to search my roommate's room, right? But at the same time, when you have conflict, you got a roommate says you can, the other says you can't. Again, the Constitution does not ignore the privacy rights of an individual who is present and asserting his rights when one occupant consents to the search while the other refuses. All right, so consent. It's another way in which you can search without probable cause. Again, plain view and open field is another way you can search without probable cause. Electronic surveillance, again, as technology becomes more complex, more complicated, I wouldn't be surprised to see more cases reach the Supreme Court in which law enforcement is using electronic surveillance. The Fifth Amendment really ties back down to the idea that no one shall be compelled in any criminal case to be a witness against himself. And basically, this really boils down to your rights against self-incrimination. And the focus, the main case here is Miranda, right? This privilege, however, does not apply to blood samples, handwriting exemplars, or other items not considered testimony. All right, so the Fifth Amendment, the police can get a blood writing or a blood sample from you, handwriting exemplar. You can make statements at a lineup. For example, if you're been charged with a crime and I conduct a lineup and I want everyone to say, this is a robbery, give me the money. The Fifth Amendment does not apply to something like that either. All right. But it does mean that as a citizen, you do not have to give testimony against yourself, incriminate yourself. So again, this is really a Miranda thing. The Fifth Amendment here really applies to Miranda. That's where we get Miranda from. People have a right to remain silent. There's certain rights that you have relative to self-incrimination, and over the years, the Supreme Court has enforced that in Miranda warnings. The triggers for Miranda are custody and interrogation. Those are the key facts. You can go ahead and take a look at exceptions to the Miranda rules. They're outlined in the textbook. There are exceptions, just like anything else. Public safety is an exception, which I do not need to give somebody a Miranda warning, and you can read about the key cases involved in that. The other thing that Fifth Amendment applies to is lineups, and those are either photographic lineups or a lineup at a jail. You have a certain right to legal representation, but only once you have been charged with a crime and you have been assigned counsel. Prior to your arraignment and you have not been assigned counsel, you do not have right to counsel. That's just the way the law is. But you can take a look at lineups under the Fifth Amendment. Sixth Amendment really has to do with assistance of counsel. The idea that everyone is entitled to legal representation of counsel. Many believe that the right of the accused to have the assistance of counsel before and during trial is the greatest right we enjoy. This goes back to 1932, one of the first cases involved a capital case in Alabama. When the accused is poor and illiterate, he or she enjoys the right to assistance of counsel for his or her defense and due process. And basically what this is telling you that prior to 1932, in some states, you didn't have the right to have an attorney. If you can afford one, you didn't get one. But now that changed in 1932 with Powell v. Alabama. Some of the other cases, again, all indigent people charged with felonies in state courts are to be provided with counsel. That was in 1963. And then Argesinger versus Hamlin extend the right to counsel for indigent people charged with misdemeanor crimes if they face the possibility of incarceration. So basically, anytime you are facing the likelihood of incarceration as punishment, you are entitled to legal representation. And if you cannot afford that, the state or the federal government, if it's a federal crime, has to provide you with that legal representation. Some more cases on the Sixth Amendment dealing with right to counsel. So again, you can take a look at these. They're all in your textbook as well. And then the Eighth Amendment, which I'm not going to spend too much time on yet because we'll talk about that as a separate topic. It has to do with excess to bail, but more importantly, it has to do with cruel and unusual punishment and typically the death penalty. We have a segment coming up where we talk about the death penalty. Okay. Again, so the short lecture, hopefully you have a better idea now of what the Constitution is, what its purpose is. Again, separation of powers, all right, within our government. The Bill of Rights, which are rights guaranteed to you as individuals. And so focus a lot more on the Bill of Rights because later on you're going to have to write a paper in which you sort of explain one of these rights to somebody who may not know much about our judicial system. All right, so just understand that there's a reason why I'm loading this up front. So we got to understand the Fourth, Fifth, and Sixth Amendment. And then the other thing I again wanted you to understand is, is the rule of law. All right, so make sure you pay attention to that area of the rule of law that's outlined in Chapter 8 as well, because understanding the rule of law is very important and applicable to criminal justice professionals. All right, guys, that's it. Have a great week.